Hello, everybody. Hello, Nana Laura. Hello, Mortimer Duke. Yeah, I'm, just preparing for tomorrow. No, just ignore it when that happens. Oh, StreamYard defaults to the next day after, I don't know, a certain time. So, yeah, it catches me. I always have to click on the calendar and change the date. And sometimes I forget because I'm me. Hello, Sir Philip. I got mail, and it's all the way from Australia. Hello, Catherine Gaston. I am middle of the country, so I am unfamiliar with any of that. I never felt a tremor, at least not from the plates. Hello, Charlie. Hello, Eileen E. Carlin. Hello, Spider-Man. Hey, look, we matched today. Get the DeLorean ready. I guess Ava's up for the ride. Yep. All right. Get you your treats because you're such a good girl. And everybody knows it. Look, Ava, you're getting love. You're getting hellos. You're getting hellos from all over the world. All right, let's see here. We've got some Australian mail. It's special. It is. I love this package. It's so easy to open. It's another one of those, the flight crew. Oh, it's stamps. And a bumper sticker from Sea Lake. Oh, and there's pins in this one. Oh. The Australian Defence Force Medal and a convoy of 2 Australian light armored vehicles from the 2nd Cavalry Regiment, patrolling as part of the Australian Security Detachment during the Reconstruction period in Iraq. Oh my gosh, these are beautiful. I love these, Sir Philip. These are so beautiful. Oh, and I look at the hat. Look at the hat. It's so Australian. Oh. She just wanted treats. She just wanted treats. And then there's a letter. Oh. Sir Philip, may I read it aloud? Well, okay. It says, Dear April, hope this note finds you well. Well, it is April here again, which brings us to another Anzac Day. As a military family that has been represented throughout the history of Australia since Federation, I thought I would get some memorial pins for you. Sorry they will arrive late, but they are not available to purchase until the week before April 25th. Wishing you all the best, both personally and for your channel. Sir Philip, I love you so much. Ava. Thank you. I have all of the Anzac stuff from the first batch you sent me. And I keep it right here. My magnet. It stays right here, right next to me all the time. Thank you so much. This is amazing. I am so blessed. And I am going to look at this lady would give Judge Webster a run for her money with those glasses. Judge Webster would be so jealous. Oh, that is so wonderful. Absolutely. It's the beard. Yours, not mine. No. Oh, yes. Dogs are sweet. And the Ava she is one of the best. She got her 3 treats and then she just darted right under the desk. We had a big thunderstorm earlier today. Lots of thunder. I loved it. Ava, not so much. She was trying to dig a hole in the carpet. I don't know what that is, but my dream was always to have a purple El Camino. That's my dream car. I have some Desert Storm hats because Papa, I've introduced y'all to Papa before. Not my biological dad, but this is Papa Henry, and he served in Desert Storm, and so I have a couple of his hats. And I cherish them. I cherish all my memories of him. He was a wonderful man. Mariner Blue Mazda Miata. I'm not a car person. Just like I'm not a sports person. I can't even pretend to know. Like, I can't even pretend that I'm good at this. You know, cars and sports. You know, I'll smile. That's all I can do. Hello, Army Brat. How you doing, love? I'm not sure. I have the no one fights alone flag, but I'm not a vet. I'm not an officer either. I'm just a child of. I euros. I'm probably even pronouncing that wrong. Is that anything like tailgating? I'm going to get so much hate in the comments. I want a car my parents had when I was younger. Marlin Fastback. Red badged and sold here as a Chevy SS. Many owners order the Holden badges and rebrand them. Interesting. Four-door Lamborghini. Well, right there, it's out of my budget. I'm quite happy with my minivan. I mean, it runs. I have a 2006 Honda Odyssey. Or is it 2008? It's in that vicinity. And my friend Corey told me a little story that he was at a dealership and talking to the guy, and he already had picked out his vehicle and was buying it and stuff. And the salesman was telling him about the 500,000 mile Honda. And Corey's like, well, I got to see this. And he's like, yeah, that thing sells itself. And it was the same van that I have. He would literally just let people go out in the parking lot and fire it up and see that it had 500,000 miles on it and still ran like a champ. And then they would buy it. Well, not that one. They would buy a new one. Hey, I had an LTD Crown Victoria. Ford LTD Crown Vic was my first car, 1984 or 86. 84. I also had a 79 Lincoln Continental. That darn thing, the trunk closed on my shoulder, and it still hurts to this day. Man, that was a heavy beast. But I bought it in singles. I was a waitress. And Don from Don's Towing, rest his soul, he when I walked in and I had all of the money in singles, he goes, look at the lettuce on that broad. He was such a sweetie. It got hit by a snowplow, and all it had was this little triangular shaped dent in the hood. That's it. Well, I had to match Spider-Man tonight. Yeah. The only problem with Fords is they don't do well idling and then get up and go, which cops kind of need it to do because they run radar and sit. But that was, my dad had to do the vehicle maintenance, and he was constantly in the Ford dealership with them over that issue. And the general acknowledgement of it was just, yeah, it's a thing. They don't idle and then jump. So, yeah, I don't know how you can make a police car that doesn't just vroom vroom. I have not. No, I have not. I also had an 84 Dodge Aries. Grocery go-getter. I really like vehicles with storage space. You know, because who knows when you're going to need to just put a pillow back there and take a nap. And now we take that stuff for granted. You can't even get a manual crank window anymore, I don't think. The makers kept their engineering centers, which still do much of the design work for Ranger and Bronco. Oh, I didn't even know Rangers and Broncos were around. I'm not going to try to pronounce that because I would get it wrong. Okay, it's either Bathurst or Bathurst. The police interceptor version. Ooh. Ooh. That just sounds like fun. All right, guys, let's get into the cases. Oh, I clicked that too early. Whoopsies. Darn buttons. Bathurst. Okay. I never claimed to be smart, just cute. Forgive me. All right, what did I name this one? Ah, fitting.
Mr. Dean,
Good morning, Your Honor.
Palmer, step to the podium. 250496 FY People State of Michigan versus Deontay Anthony Palmer, charged with count 1, assault with the intent to do great bodily harm, less than murder or by strangulation, and count 2, domestic violence. Appearance on record.
Good morning, Your Honor. Laura Kamaj on behalf of the people.
Thank you. Good morning, Your Honor, and thank you for allowing me to appear by Zoom. Michael Dean, P32631, attorney for Mr. Palmer. We agree to conduct this proceeding today by Zoom, or bifurcated. Thank you.
Palmer, good morning. State your name for the record.
I was Deontay Palmer.
Okay, so we're here for an emergency motion to revoke bonds. Go ahead, Mr. Myers, this was filed by the people.
Thank you, Your Honor. Yes, the people were made aware that the defendant has been trying to contact the victim in this case. There is a no contact order in place. I was made aware a police report was filed. I did just forward that to Mr. Dean for his review. It's pretty brief, so I don't anticipate that it should take him long to review. But the defendant did go to the victim's place of employment, asked about her work schedule. I believe he called again, asking about, again, her work schedule and when she would be there. The officer in charge in this case was able to obtain surveillance footage from the date that the defendant went to her place of employment asking about her, and was able to obtain not only the surveillance footage, but did attach screenshots in the police report and was able to identify the defendant in the video.
Mr. Dean.
Thank you, Your Honor. I have had a communication and talk with my client, and if I may allocate at this time, my client does indicate and will state that he did go to the Home Depot after he was released from the Oakland County Jail on April the 15th of this year for the purpose of basically trying to locate his van. There was a police report made by his mother, the owner of the van that my client uses, that the van was stolen. And basically, I have a criminal report number CR 250085766. That van was reported stolen on April the 15th at 8:50 in the morning. And basically, my client was released from the Oakland County Jail on the 15th at 7 o'clock, and along with his grandfather went to the Home Depot to look to see if the vehicle was in the parking lot, which they did not see, and then to inquire about when the alleged victim might be working next in order to gain access to the vehicle. Bottom line, Your Honor, the vehicle was recovered in Taylor, Michigan. The alleged victim in this case is being charged with unlawfully driving away a motor vehicle, possession of a stolen vehicle. That being said, the only time that my client has, and since had made attempts to contact the alleged victim, was on the 15th. And I'm not aware of any follow-up phone call, but since the 15th, he has made no attempts or has had no contact with the alleged victim in this case. And for that reason, I'm asking that he be allowed to remain within the community pending the outcome of this case. Thank you.
No contact means no contact.
Judge, I would just like to indicate for the record, it doesn't matter why the defendant was attempting to contact the victim in this case. The bond conditions are very clear that he has to have no contact. He is well aware of those conditions. So the reason for the contact is irrelevant, Your Honor.
Mr. Pawfurm, would you like to say anything?
No, Your Honor.
Yeah, I mean, we're very clear. So there was contact. So you were arraigned on the 15th of April. And I'm pretty sure Magistrate Angela Thomas Scruggs clearly told you no contact with Lauren Holloway. We're not to possess any firearms, ammunition, or dangerous weapons. And then you are not to have any assaultive behavior with anyone. So that means fighting or whatnot. Gave you a $1,000 personal bond. And after you were released, ran and released, you went and just straight violated. This was a clear, she told you the same day her bond condition, and then on the same day you went and violated your bond condition. Not only did you violate on the same day, you went back a couple of days later inquiring, you know. So yeah, I don't like that.
No, me, Your Honor.
You may, but I don't know if it's gonna change my mind. Go ahead.
I'm aware that, just as Kamash said, that, you know, it's irrelevant and there's no excuse. I wasn't trying to go out of my way. Maybe my family was egging me on, but I was looking for my vehicle because it was stolen. This is the only.
So how come you didn't call the police? I mean, you called the police. How come you didn't just say, well, to the police, hey, Lauren Holloway may have my vehicle. She works at Home Depot, and let them follow up. You know, you're looking for a justification for a dumb decision that you made. There's no justification for dumbness. It's not. You were literally told not to have contact, but then you go and search for the girl the same day. That's a big F you to the court. Like, I don't care about care what you say. I'm gonna go find my property. So, so yeah, I will grant the people's emergency motion to revoke bond. And therefore your bond will be revoked and you'll be remanded to the Oakland County Jail. And we'll see you for your preliminary examination on May 27th at 2 p.m. You'll be brought over.
And
So you have to say your job, you in jail today. So
is there any way I can like make a phone call right now so that I
you can make it when you get over to jail.
right now?
So you're all set. So his bond is revoked. We'll see him for an exam on the 27th of May.
So I'm gonna remain in jail till the 27th.
Correct. And let me tell you something. All calls are monitored and recorded from the jail. I'm gonna leave it right there. So if you call her, they're gonna pick it up. That's gonna be more charges, more trouble. So you're all set. Second.
Thank you, Judge.
All right. Thank you, Mr. Dan.
His body language right there when the judge said all calls are monitored he kind of went, oh man, kind of like a little toddler.
Thank you, Your Honor.
Sorry to bother during your vacation.
Thank you, sir. Bye-bye.
All right, good morning. This is the matter of Dietz versus Dietz, case number 22-09000 DM. Both parties are present in the virtual courtroom, and both are represented by their attorneys. Ms. McLean on behalf of the plaintiff, Ms. McClure on behalf of the defendant. This is well, actually, we have two motions. We have the defendant's motion to modify parenting time, and we also have the plaintiff's motion for de novo review. I think we'll take the plaintiff's motion for de novo review first. I have read the motion, the response. I've read the transcript. There was a order entered prior to this hearing that indicated that the de novo review would not consider any additional evidence that was not available at the time of the referee hearing. That was not available at the time of the referee hearing. And that the parties, if they believed that there was evidence that was available and that they wanted to present to the court, that they would inform the court at least 7 days, I believe, before the hearing. And I have not received any information that would lead me to believe that that's the case. Ms. McLean?
Thank you. And I didn't think that I would need to do that because there hasn't been anything new except what was presented beforehand. Now, that being said, the concern that my client has is that he was self-represented at the time. And, you know, what's happening right now with the
All right,
defendant.
let me just stop you a minute because I had a very specific question. So, Ms.
Okay.
McClure, how about from you? Is there additional evidence
No.
that you wish to present?
No, Your Honor.
Okay. All right.
Okay.
Then the court is prepared to render a decision on the de novo motion. The legal standard for custody modification requires that a parent seeking to change custody must first establish either proper cause or a change in circumstances in the child's life since the last order. It's a threshold requirement. And the court finds that there are sufficient allegations, if proven, to support the court looking at custody so that there is proper cause or change in circumstances or allegations that the defendant has failed to provide basic hygiene and care, that the defendant has left the child unsupervised, that she's not participating in the autism therapy, failing to engage with the child's educational needs, not seeking medical care regarding lost classes, that there was a very recent domestic violence case involving the defendant, that there's been a significant change in the child's living situation. And this is all with a child who has autism and requires 24/7 care. So again, I'm not finding that any of those allegations are true. I'm simply finding that they're sufficient for the court to have a look at this. So the court will refer this to the front of the court for an investigation regarding custody, parenting time, and support. Moving on to the motion to modify parenting time.
I think, and these issues are clearly tied together, and if the court is referring this for a review of parenting time, it will be addressed with the front of the court, I assume. But at this point, the biggest issue has been that pursuant to the judgment, the plaintiff, it says the plaintiff shall attend up to 2 ABA appointments a week. It doesn't say anything about when and how and where. And ABA therapy can occur anywhere. I confirmed this I had a long conversation with the ABA supervisor about this child, this case, and what he needs. And it's likely that his at this point, he goes for several hours, 4 times per week. It's in home or wherever the parties want it to be. It can be in either party's home. And the plaintiff has insisted that it continue to be only at the defendant's home, even when he goes. And so he's making all these allegations about her and then insists on being in her home for this ABA therapy. The therapist, I will say, has noted neither of the parents have complained about each other. She did note that the defendant's mother had said
I'm
horrible
just going to
things about
object
the
to any of
plaintiff,
this
but
hearsay. It's hearsay.
understood. So is everything that was in the plaintiff's motion.
I would agree. I agree, and I don't want to get too far in the weeds in here because like I said,
Yeah.
I
Get an
read both.
affidavit.
I spent a lot of time yesterday reading the motion and the response. So
Right. So, and again, this is the point is that the ABA therapy happens 4 times a week. My client has told me, and I have confirmed that it's likely going to be decreasing over the next few months, especially by fall when the child starts school. And so I think it's going to be sort of impractical for the plaintiff. There might not even be 2 ABA appointments per week. But even more importantly, it is nonsensical for the plaintiff to attend ABA therapy in the defendant's home when he could have it at his home, or he could attend it in the community. We just need to discuss that. So, I don't know if it makes sense to change the parenting time schedule exactly as I've requested at this point, knowing that parenting time is going to be reviewed and that ABA therapy is going to be changed. But I guess what we would like at this point is that the plaintiff, when he attends ABA therapy, that the ABA therapy happen in his home, or at least not in the defendant's home. That's the main crux of the issue for this morning.
right, thank you.
My client has no problem with doing the ABA therapy when it's on his time in his home. The problem is that it's been always in her home, even during his time, and he has a right to be there and attending the therapy. So if we want to expand the times the child can during the ABA therapy, my client's going to be able to get the child and have therapy in his home. He's happy to do that. He can pick the child up and bring the child to his house, and he can do the therapy at that time.
All right. Well, as I said, I did spend some significant time looking at this yesterday. So I will order that any ABA therapy that occurs during the plaintiff's parenting time be at his home or in the community, but not in the defendant's home. That the defendant shall not enter the defendant's home at any time. That both parties are to follow the ABA therapist's recommendations consistently. That the defendant's parenting time, during the defendant's parenting time, only she and appropriate child care providers can supervise the child, so that the boyfriend, who's part of this whole issue, is not supervising at any time. That any child care arrangements be communicated to the plaintiff in advance. And I'm not saying that hasn't happened. I'm just saying, I'm just going to clean up the order. It sounds to me like this child should be exchanged at a neutral location. That wasn't requested, but I guess I'd like to hear about what the response to that is.
Well, Your Honor, I don't, I think that these parties have actually gotten along fine. It's the third parties that have maybe caused an issue.
Okay, so you don't have a problem with, or your client doesn't have a problem with the plaintiff coming to her house to pick up the child?
I think as long as he doesn't come into the home, it's not an issue, Your Honor.
Okay, then I think I've made that clear.
My client is asking that they meet at a neutral location. He doesn't feel comfortable with these allegations and everything else that's going on. He doesn't feel comfortable.
I just think that's really odd because the plaintiff, as recently as this week, insisted on coming into the defendant's home to attend ABA therapy. She tried again to get him to agree to attend ABA.
Because he couldn't attend.
All right,
Ms.
McLean, we can't all talk at once. But yeah, I given the allegations here and the tension, I really think a neutral location is appropriate. And is there somewhere that's convenient halfway between the parties that would be appropriate?
Asking him right now.
Well, Your Honor, my client doesn't have a vehicle right now, so I don't, there isn't a convenient location for
Walker
her.
Police Station. It's halfway, my client says,
If
halfway between the houses.
Okay, all right, wait. How old is this child?
he's 4, about to turn 5, I think.
Okay.
No, he's 5. He's 5. Sorry.
Is he able to walk out the door and go to
No.
the
Yes.
vehicle
He's
I
not,
think he is, Your Honor.
at the house?
he's not able to walk out to the vehicle by himself without having a parent walking with him because of his many issues that he has, Your Honor. He's probably functioning at more like a 22 to 23-month-old.
And that's not what I heard from the ADA supervisor, Your
Okay,
Honor.
okay,
So-
all right. Yeah, this is hard.
These two attorneys just cannot agree on anything as far as it relates to this child and their clients.
Then I guess parties can meet halfway in the driveway or on the sidewalk, to exchange the child. So it's not in the house.
Okay.
Okay.
So she's going to walk the child out to the end of the driveway and he'll pick the child up from the end of the driveway.
Yep. That way there's a parent with the child all the time.
That makes sense.
The court will order that our family wizard be used for all parenting communications. I have an order, kind of a standard order that I use. We'll send that to both attorneys to have a look at to see if you want to make any modifications, just because there's all kinds of options in there. But I do want these parties to use our family wizard. And I do also want to order a safety assessment of both homes, just to make sure that they meet the needs of a child with autism, because it is a little different than perhaps a standard front of the court investigation. So I'm going to include that in my order of referral.
Okay, thank you, Your Honor.
And then I'll have the parties split the cost of the referral.
The $300, $150 a piece.
Yes.
And when does it need to be paid by?
The front of the court contacts people. I think it's within 7 days.
It's 7 or 14.
Yeah.
The other thing is, if one person ends up paying it all, because sometimes the party won't pay it, and then it will get just basically the order of referral is set aside or it's vacated because of lack of payment. If, for example, my client ends up paying the whole thing, would he be entitled to be reimbursed the $150 down the road?
Yes.
From
Yes.
Okay.
Yes. Yes.
I want to make sure that's in there.
Yes.
Okay.
And is there anything further?
I don't believe so. I think you covered it all. Thank you, Your Honor.
All right, the court will make the referral to the front of the court, but Ms. McLean, I'll ask you to prepare the rest of the order.
Happy to do so. Thank you, Your Honor.
All right, thank you. We're adjourned.
Thank you.
There is no reason that either party's significant other needs to be so involved with handing over the child and doing transfers and things like that. It's these two people's child. Having your boyfriend come in is only going to cause unnecessary tension. And it's unnecessary.
The court can call People versus Arapage, date and time set for a sentencing on 2 files.
Morning, Your Honor. Melissa Simmons on behalf of the people.
And good morning, Your Honor. May it please the court, Camilla Barkovic appearing on behalf of Mr. Arapai, who is present.
All right, hold on 1 minute. Your client waives his right to be physically present, counsel.
That is correct, Judge.
All right, Mr. Ramsky, the guidelines 12 to 24.
12. Excuse me 1 second. They are 12 to 24 on count
12 to
3.
24 and 14 to 29 on each file.
Yeah, on count 4, 14 to 29.
Go ahead. All right. Go ahead, Ms. Barkovic. You reviewed the PSI?
Judge, I have reviewed the PSI. I have one comment as it relates to guidelines, which in effect would not actually changed the scoring, but I believe OV 19 to be scored incorrectly in the sense that there was no force utilized or threat of force utilized by the defendant during this incident. He simply drove away from a traffic stop and stopped his vehicle at the Sterling Heights Police Department.
Ms.
So
Simmons?
Judge,
Response?
the report indicates otherwise. It is not simply that he drove away. It's that he nearly hit a scout car, fled police through a subdivision, put both officers and the community in fear, but nearly struck a scout car when they were trying to create a blockade. Only through the use of spike strips and the defendant driving on his rims did he end up at the station. He was certainly putting officers at risk and using force to evade their arrest.
That's a little bit different than he simply pulled over at the police station, you know, just a little ways down the road. I mean, if you're pulling over on your rims, there was probably something going on.
And he's charged with fleeing, but where's the obstruction of justice, Ms. Simmons?
In that he did not stop and instead used force against officers, putting them in fear, driving at their vehicles as they tried to stop him as he fled them.
All right, I'll rule it's appropriately scored. Anything you want to
Thank
say on
you.
his behalf, Ms. Barkovic?
Yes, Judge.
I intend to follow the cops, by the way.
Yes, so the only other correction I have as it relates to the report is jail credit. You indicated at the time of the cops that you would give him credit for all time that he served in Oakland. He had been in Oakland since November 15th through April 4th. That is 141 days. He had pre-existing credit in the amount of 22 days, therefore his total is 163 days. So I'd ask that modification be
So I
made.
don't recall that conversation, Ms. Barkovic. I usually make a note if I'm going to do that. Is there anything in the prosecutor's file with respect to that, Ms. Simmons?
I did see on the face sheet of the PSI report, Judge, that the defendant was to receive jail credit while in Oakland County Jail.
And
Oh, I do see that now. All right, so I will do that. Do you agree with that credit calculation, Mr. Rapsky?
Yes, Your Honor, with that new addition, 163 days.
163 on each file, right? Or each
No,
file?
just the 0533 file, I believe.
the other case was dismissed or will be dismissed at the time of
Right,
sentence.
right. So on each county gets 163, which should have been my question. All right, anything else you want to say on his behalf?
Judge, I'm asking that you not impose any further term of incarceration with good time. He is effectively at the 6-month cap that you agreed to. He did serve a substantial amount of time in the Oakland County Jail. He's been out for a month. He's back to work. He's re-enrolled in treatment in care. In addition to that, while this matter was pending for an extended period of time, he completed inpatient treatment, was actively involved in outpatient treatment, and maintained full-time employment. He's accepted responsibility for his actions, and you're going to have no further issues with them.
All right, on the file 870, was he not violated, Mr. Rapsky?
No, Your Honor, I
Was he
believe
not on probation?
neither. I believe that case is dismissed part of the plea on the 0533 case.
Yes, Judge, at the close of this hearing, I would move for its dismissal.
All right, that's fine. Mr. Arapaja, anything you want to say? I can't hear you. Speak up. Looks like you said no. Is that right? Nod your head if it's no, you have nothing to say. You're not audible, Mr. Arapaja.
Pardon?
All right. You weren't
Hand
audible. You are now. Is there anything you want to say?
I just want to say I'm sorry to the court for having to waste as much time as we've had to waste or spend. I am grateful that there are no injuries, and I look forward to demonstrating that nothing like this will ever happen again, and demonstrating the opposite of anything that was demonstrated. I just thank God that I'm here today and I was given this opportunity to do better, and this is what I'm going to do.
Thank you, Mr.
All right,
Arape.
it is sent to the court. You'll be placed on probation for a period of 2 years. On each of your 2 counts, I'll order that you serve 163 days in the Macomb County Jail. Credit for 163 days time served. You are not to use drugs or alcohol. Seek and maintain employment of at least 30 hours per week. You're to complete the Class A Training Center program on impulse control. You're to pay $268 state costs, $130 crime victims' rights assessment, supervision fee of $30 per month, court cost of $100. Sir, you're entitled, as a matter of constitutional right, to file an application for leave to appeal your conviction and sentence. If you're financially unable to provide counsel to perfect such appeal, this court will appoint counsel for you. Request for assistance of counsel must be made within 6 months. Counsel, you're to get assigned advice rights to the court.
Yes, Judge, I will. Thank you.
And then, Your Honor, if I may, would you like to add a testing requirements for him?
Sure. Twice monthly random tap, 6-panel.
Thank you. And then would also recommend a condition if he is participating in outpatient treatment at care, add a condition that he fully participate and successfully complete that treatment.
I will impose that as well.
Thank you.
And then one more, Your Honor, as it was a driving offense, that he must not drive a vehicle without a valid driver's license.
Yes.
Thank you.
Your Honor, at this time, people move to dismiss counts 1, 2, and case ending in 0870.
Granted.
We have Daryl Buggs. Mr. Buggs, good morning. Mr. Buggs, you're here originally for a fugitive warrant out of Houston County, Alabama. Warrant they say they want you on, Mr. Buggs. The clerk's office this morning discovered 4 old warrants from Jackson County that you were sentenced on. These are old issuing worthless checks. It's the same name, same date of birth, Mr. Buggs. And these warrants, do you have those warrants? These warrants are from 2006. 4 different are issuing worthless checks in 2006. And in each case, all of them are essentially the same. It looks like you appeared before Judge Hatcher back then. According to the court file, he sentenced you to 90 days in jail, but the jail sentence would only apply if you did not pay some restitution and some total check fees. It looks like the total you were ordered to pay back then was $530.95. Somehow during the booking process yesterday, it appears someone missed those old warrants. So I'm making you aware of them. I'm going to ask Sergeant Applewhite to notify the Sheriff's Department that they need to be served. So hopefully someone will be out there today and serve you with those. So what that means is you've got to deal with these charges before you can deal with the Houston County charge, because you've already been sentenced on these cases. So when you get a copy of the warrant served, you'll get a copy of the information, the case number, and so forth. But I have got a copy of the disposition in front of me. I know this is the first time you're hearing about this. I did look at the checks to see. I'll try to answer your question in just a second. I did look at the checks because I wanted to see where they were written to. 3 of them were written to Malone IGA. 1 of them was written to McDaniels IGA and Sneeds. Those are the checks that it appears you've already pled to and been sentenced on. So you'll get copies of those today. Right now, there's not a purge amount on the sentences. Okay, so listen to Mr. McDaniel. I think he's going to ask that a purge amount be added, and then I'll answer the questions you have in just a second. Mr. McDaniel.
So, Mr. Buggs, you've already been sentenced to 90 days jail, and I'm going to ask the court to modify that sentence to allow you to purge out of jail, be released from jail by paying the sum of what the checks are. That's $530.95. Once that payment's made, you can be released on that 90-day sentence on these worthless checks. We'd ask the court to amend that.
Mr. Mitchell, any objection to that?
What was that total purge amount again?
$530.95.
95 cents. No objection.
So, Mr. Buggs, Mr. McDaniel wants you, if you wish to and have the ability to, he wants you to at least have the option of paying that purge amount and being released on these sentences, not serving the 90 days, because that appears what Judge Hatcher was trying to do way back then was just collect restitution for these businesses. So Mr. Buggs, you understand with the motion he's making?
If back then, if I'm mistaken, I thought they gave me 6 months probation on that after I left out of the courts, and I did the probation on that.
According to the court file, that's not what happened. Judge Hatcher sentenced you to 90 days in jail on September 11, 2006. 2006, there's probably a video from the court appearance. It's probably actually an old VHS tape. There's probably a video from the court appearance. If you want someone to, if you want to try to dig it up, we can do that. Obviously, it's not going to happen today, but there's probably a video from the court appearance. We can let you see it at some point in the next few days.
Yeah, cause see, I ain't never been in no trouble here in Florida. That one time they locked me up one time in jail, and I went to court. They gave me probation, and I had
Let me do
6 months
this.
probation.
Let me take a look at one of the checks and tell you what address was on the checks, and then you'll know if you ever lived at that address or not.
Because I don't even. Was they my checks?
They were written to those grocery stores I just named.
I don't even recall those grocery stores. I don't even know a grocery store in Sneeze like Malone. Them grocery stores in Malone.
Which is it? Did you think you got probation, or do you not remember it at all? Because there's those two kind of don't.
I had a probation thing here for once. That's the only thing I ever had.
Okay. On the checks, there's an address of 4160. Listen to me. On the checks, there's an address of, you know what else is on the check? There's a driver's license number on the check.
Okay, is it 731?
Is what? Is the number you just gave me is not a driver's license number. What are you asking me?
That's my driver's license number.
No, did you have a Florida driver's license at one time?
I got Alabama driver's license.
Did you have a Florida driver's license number at one time?
I have Alabama. I never had Florida driver's license.
Okay. Yeah, so y'all have a Florida driver's license number on his first appearance sheet today.
It's not a Florida driver's license on my first appearance. I have Alabama.
Corporal Jones.
Yes, sir. I'm grabbing his file.
That's what.
Thank you.
That's what was written on the report was a Florida driver's license.
No, it's Alabama. My driver's license is 731 out of Alabama.
Okay, we're going to take a look at this driver's license number and the picture of the photo of the person that has that driver's license number. B200. Can't read that. 163.
And the only thing I've ever been I've been here at y'all jailhouse one time, and it's been a long way before that time. And I was put on probation for 6 months, and I completed it.
Something.
You confirmed his middle name. Dispatch that there were two Daryl Buggs with the same DOB, different.
Really? Okay, so dispatch at the sheriff's department is telling us that there are two Daryl Buggs with the same middle name, same date of birth, but different middle names. What's your middle name, Mr. Buggs?
My middle name is Canisius.
Yeah, that's the name that's on this warrant. B200 163. I think I had an extra number in there.
Just like yesterday, told me they had two paperwork for me with two different socials or something, somebody else and me. And I got Florida, I got Alabama driver license, and they are accurate.
Did you ever live at 41?
That's not no, sir. I don't even know where that's at.
In Greenwood?
No, sir. My father lives in 2A. That's the only address I ever lived at.
The photograph on here is from 2005. So we got a 20-year-old photograph. So it's really of limited value.
Let me see it.
That record is transferred.
I'm curious. No, but it does show a state of birth, a state of Alabama, state of birth, Alabama. See, that's the 20-year-old photo we have.
That's not him.
Well, I appreciate that expert opinion, but I don't know if it is or not.
I just looked at it. I mean, you can't see some of the features.
I have no idea.
That's not me, young, because I don't know about the address or nothing. I live in Alabama all my life. My father lived in 2A, I got Alabama driver license, and had them for many years. I was
Having
CDL.
two Daryl Bugs. Having two Daryl Bugs is coincidental. Having two Daryl Canisius Bugs, that's not a coincidence. It's almost unfathomable that you would have two people with that name and the same date of birth. That's just hard for me to imagine. So,
well, I know I ain't know.
Let me see if we got anything else in this file. See if there's any fingerprints or anything in here we can. Okay, what about the signature from today compared to the signature on the checks? Let's take a look at that.
I don't think it's in here.
All right, so there's a signature on the check. And that's not it.
You do share screening?
I'm sorry?
You do share screen, on the Zoom? I mean, just show them that picture if you can share the screen.
We don't have the ability because the jail's not connected to Zoom. We're connected to them through the Polycom. So I thought there was a sheet they signed from the jail, Don. Oh, there it is right there.
If there's anything else, somebody done used my did something, got some ID or something in my name or something, but I don't have no driver license in Florida. Never have.
It says refuse to sign. So did you refuse to sign your fingerprints yesterday?
That's because I told them I didn't have no charge here and I shouldn't have it. He said, if you feel like you don't have a charge, you don't need to sign, because what I'm here for now, I don't have a charge. I was arrested yesterday. They ran my name and realized I had a hold out of Alabama for VOP. When I got here, they tried to tell me I had a grand theft. I said, I don't have no grand theft. I ain't never been charged with nothing. I don't have nothing. He said, well, if you don't feel like you have a charge, you don't have to sign it. That's the only reason I didn't sign. But there's other paperwork here that I did sign.
Mr. Boats, you live you live in Greenwood?
I live in Alabama at 95. I just oversees him. I'm his caretaker. He's 78 years old.
So you put the Florida address on your form at the jail yesterday because you put the Wintergreen Road address.
Yeah, so I can make sure that my father gets all information that's concerned while I was here.
Yeah, they're trying to compare a 20-year-old signature and a 20-year-old photo to the guy that's standing in front of them right now. I don't look the same as I did 20 years ago. I mean, I look a lot better than I did 20 years ago, to be honest. But yeah, I know my signature's changed for sure.
Okay. So here's what we're going to do. You've got Alabama saying they want you. It is what it is. You've got to deal with the allegations in Alabama.
Right.
As to the Florida allegations, we'll let the sheriff's department figure out if they think you're the same person that's got a warrant or not. So I want to ask the sheriff's department to look at the warrant, and if someone needs to go out there and determine if they think it's the same person or not. They do that all the time. That's their job. So if they serve you with these 4 warrants, then we'll deal with those at first appearance. In the meantime, you've still got a hold out of Alabama that you've got to deal with. And at this point, you're choosing not to sign a waiver of extradition. Is that right, sir?
Oh, no, I want to go to Alabama. I'm ready to go to Alabama now.
He's got local charges.
Sorry, I couldn't hear you.
He's got local charges.
Grand theft.
The grand theft's here?
Yeah.
Well, I thought the grand theft was in Alabama.
It's here.
Okay.
That's the thing that I did not sign, that I told them that I don't have nothing here in Florida. I don't have no warrants here in Florida. I don't have any caught no charges here. I haven't did nothing in Florida to have no grand theft.
Give me a second to read the local charge. Let's see what the local charge is related to.
That's what I was explaining to the attorney or somebody who was here today. I said, I don't have any charges in in Florida. When the officer brought me in yesterday, we didn't talk about no charges against me here. And I didn't have nothing. And they must told me I didn't have anything here. I'm just being brought here, being held for Houston County. But then when I get inside of here, they tell me I'm being charged for a grand theft. I'm
having a hard time reading it. If you'll give me just 30 seconds to read this complaint, that'd be helpful.
I'm sorry.
Thank you.
Yes, sir. I apologize.
Okay, so Mr. Bucks, you do have a complaint from yesterday where you were arrested for one charge of grand theft. I have read that complaint. There is probable cause for grand theft. It involves a lawnmower. So in that case, you're entitled to a bond. So this is, I know this is confusing. It's confusing to me. I'm going to set you a bond of $5,000 cash or surety on the case from yesterday with a condition, no contact with the alleged victim. In addition to that, right now, it appears you have a hold from Alabama. They're saying that you're the person that they want in the state of Alabama. And I don't know that we even know what the charge is up there, but Alabama's saying someone with your name and date of birth is who they want, and that's something we'll deal with at a later date. If you post bond, we'll deal with it then. If you don't post bond, you'll resolve your local charges first, and then we'll deal with the state of Alabama. The third issue you have are these 4 old issuing worthless check warrants. The sheriff's department's going to be looking into those and determining if they think you're the same person that has these warrants or not.
And they can use my signature stuff up here. I know I didn't sign that warrant thing, but I've signed a lot of more things up here.
That's signature from what, Mr. McDaniel? Okay, that's the signature on the check from it's hard to say, it's 19 years ago. That's the signature on that check. If you request an Alabama driver's license, can you get a photo history too? Alabama only gives you driver's license. So, Mr. Bugs, that's where we stand. You've got one charge here with a bond. You got 4 charges that they haven't served you with. They'll have to make a determination if they think it's you or not. And then the 5th issue is the 6th issue is the Alabama charges they say they want you for up there. Do you have any questions, sir?
Yes, okay, you got the bond for $5,000 for this charge that I'm not aware of. I can't make a bond. I guess I don't have my father's, I don't know what I gotta do with this here.
The $5,000 bond is for the lawnmower theft you were accused of, that you were arrested for yesterday. That's what the bond is for.
Can I get an R&R so I can be expedited to Alabama on this charge that y'all have me for?
No, sir, not with a felony, that you're accused of. I wouldn't give you an ROR. With a criminal history I've got here too. Now, that's where things stand. All right. Wish you the best, sir. If the sheriff's department determines that's you on those warrants, they think it's you, then I'll see you at first appearance tomorrow on those 4 worthless check cases. And we'll try to see if we can get you copies of those checks so you can see the signature on the checks and the address on the checks.
And if they discover that none of that has to do with me, no kind of stuff, can I get the R&R on this charge I have now to be released to Alabama?
No, I wouldn't give you an ROR on a Florida charge when you already have an Alabama warrant anyway. I wouldn't do that. I would set you a bond, which is what I've done. If you've got an Alabama charge and now you've got a new charge in Florida, I'm not going to give you an ROR with your criminal history.
But see, yeah, my only thing, well, I know you said I explained it to you about Alabama because therefore I just have a VOP, which is going to be dropped once I got there because I've already seen my probation officer and this charge should not have any still exist. But I know that you don't have anything to do with that part. So I won't have nothing to hold me once I get to Alabama besides being released. Is the thing it's going to be hard for me.
That may be correct. It may not be, but you've got a bond today. Have a good day, sir. After Mr. Bugs, we have Willard Porter. Mr. McDaniel, that's it for friends or family. So let me go back to the top of the docket. Unless you take somebody out of order, the top of the docket would be Daryl Bugs. Mr. Bugs, good morning. Mr. Bugs, you're here again. I saw you yesterday on what we thought was these 4 counts of issuing worthless check. Mr. Bugs, the sheriff's department has investigated the identity of the individuals involved, and their conclusion is that you are the same Daryl Bugs that was entered this plea back in 2006. So, Mr. Bugs, Mr. McDaniel made a motion yesterday for me to add a purge amount to this, and we kind of got sidetracked after that, and I don't think I formally did that. Anything you want to tell me about his request to add a purge amount to the sentences that have been imposed in this case, these cases?
Yeah, we just asked that purge of $530.95 be amended to add that to the sentence, be purged out with it by paying that sum.
Mr. Mitchell, you still okay with that?
Yeah, no objection.
Mr. Bugs, I'm going to add a purge amount. So what I'm doing basically is I'm amending your sentence that was imposed in 2000 and what year? 2006, because it didn't have a purge on it. It was just a flat jail sentence. But now you've got the purge. If you have the ability to pay and you decide to pay, you'll be released. If not, you're serving that sentence unless and until there's some other kind of pleading filed. So the purge amount is $530.95. And Mr. Buggs, that doesn't change your bond in the other case. It doesn't change your Alabama hold that we discussed yesterday. Do you have any questions, sir?
No, it's not.
Have a good day, sir.
Good luck to you, man.
Yes, sir. That brings us to William Bell. Mr. Bell, good morning. Mr. Bell, you're here for first appearance accused of one count of driving under the influence for your third violation within 10-year period. That's a felony charge, and one count of driving while license suspended or revoked. That's also a felony charge. Mr. Bell, there is probable cause for these charges in the complaint. I looked at your criminal history, which is not good at all, but what was even more concerning is your driving record, which I'm pulling back up again now. Mr. Bell, I believe, I'm pretty sure you have the most DUIs I have ever seen since I've been practicing law, which is about 30 years. I think you have 14 prior DUI convictions, but I'm pulling that driving record up again right now to make sure that that's what the Florida driving record reflects. It does. It shows 14 prior DUI convictions, not charges, convictions, and 6 prior driving while license suspended. So let me see if the attorneys have any additional information before I set your bond in these 2 charges. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell?
Your Honor, we would just, I mean, it's kind of obvious this condition, but we request that as a condition of his bond, he not be allowed to drive.
Mr. Bell, based upon your DUI record, sir, I'm going to set your bond of $50,000 in each count. I feel like you're a danger to the community based upon your refusal to quit driving while under the influence of alcohol. So you have 2 $50,000 bonds. You obviously have a condition not to drive a motor vehicle, and you have a condition not to possess or consume alcoholic beverage. That means your total bond today is $100,000 cash or surety. You have the right to post the bond. You have the right to use the phone to try to post that bond, and you'll get a chance to do that after first appearance. If you do post the bond, remember, no driving. You cannot possess or consume alcohol at all. Mr. Bell, do you have any questions, sir?
No, sir.
Wish you the best, sir.
Thank you.
14 prior driving under the influence convictions or driving while intoxicated convictions. I want to know how many charges there were, because you got to figure if there's 14 convictions, there had to have been cases where he was charged and then they maybe dropped it or amended it or did something to it like they do very often. That is insane.
Is there anyone else appearing from the jail, or can I remove them?
I don't believe we have anybody else from there, so please feel free to do that.
Okay.
Thank you. All right, the next case on the court's docket is Mackenzie Wanfer, 25-43382-FY.
Thank you, Your Honor. Richard Truish appearing on behalf of Ms. Wanfor.
All right, I have just, looks like this is set for sentencing. Is that correct, or is this a different case?
It's set for a status conference, Your Honor. We do have a resolution for the court. I did send over the substance abuse assessment because it already had been completed. I'll leave it to the court's discretion if the court wants to proceed directly or if the court wants to come back at a different date for sentencing.
All right, well, why don't we process it first? I did just receive it, but I've not had a chance to read it. So if we get that far and I need to, I'll take a minute, but let's proceed to where we're get to that stage next. All right, would you go ahead and place the agreement on the record, please?
Yes, Your Honor. Ms. Wanfor will be pleading to a single count of attempted R&O as well as the OWI, and the remainder would be dismissed.
That is accurate, Your Honor.
All right, so the OWI is count 3, and there's going to be an attempted R&O, and then counts 1 and counts 2 would be dismissed. Is that right?
Correct.
All right. Ms. Wanfor, you've heard what the lawyers have said. Is that what you want to do?
Yes, Your Honor.
All right, what that means is you're currently charged with 2 counts of police officer resisting and obstructing. Those are both felony offenses. The attempted resisting and obstructing would be a 1-year misdemeanor offense, maximum penalty of 1 year and or a $500 fine, I believe. The count 3 of operating while intoxicated would also be a plea. So in effect, you'd be pleading to 2 charges and for reduction or for dismissal of the 2 more serious charges. Do you understand all that?
Yes, Your Honor.
Do you have any questions about that?
What do you mean when you say 1 year?
The maximum possible penalty for the reduced charge of attempted resisting obstructing is 1 year in jail. I'm required to tell you what the worst case scenario is. So if you look at the 2 charges for police resisting obstructing now, they're listed with a maximum penalty of 2 years. So the reduced penalty goes down from 2 years to 1 year for the 1 attempted resisting obstructing that you're proposing to plead to. Does that make more sense?
Yes, it does.
All right. Do you have any other questions?
Yeah, I guess a lot.
Well, do you want some more time to speak with your attorney about this?
I wasn't aware that there was a penalty of 1 year in jail.
Well, every charge has some penalty, so I'm required to tell you what that is so that you know it.
Right. Yeah. No, I know that.
Okay, and it doesn't mean that that's what you're going to get. It just means
Okay.
that that's the worst case. I don't have any idea what sentence is going to be at the moment. I haven't thought about it yet. I haven't reviewed the substance abuse assessment that you've done. I've not even decided if we're going to do that today. But I am required by law to tell you what the worst case could be, and then we kind of go from there. So just because we say it's 1 year doesn't mean you're going to do 1 year, but I have to tell you that by law.
Okay, I understand.
Any other questions that you have then?
I don't believe so.
All right. Right now you have certain rights, and I'm going to tell you what those rights are in just a minute. If you enter a plea today, however, you'd be giving up these rights. So I want you to be informed of them so that you can make an informed decision. The rights are often called your trial rights. If you wanted to have a trial, you could have a trial by a judge or by a jury. You could also see, hear, and question all of the witnesses at trial. You could present witnesses for your own defense. You could get a subpoena from the court to require those witnesses to appear and testify in your defense. You could be a witness for yourself, or you could remain silent as you choose. And if you choose to remain silent, that silence could not be used against you because you have an absolute right against self-incrimination. At trial, you'd also be presumed innocent until proven guilty beyond a reasonable doubt, and you'd have the right to have that burden of proof be on the prosecutor at all times. If you had a trial, you'd also be able to appeal anything that you felt was wrong that happened at the trial, and you could do that automatically. However, if you enter a plea, you have to ask the appellate court for permission to appeal, and they could say no, and that would be the end of it. You understand all of those rights that you would have at trial, but that you would give up if you enter a plea today?
Yes, I do.
Do you have any questions about those rights?
I do not.
All right. Knowing all of that, do you still wish to enter into this plea bargain agreement that you've reached on the record today?
Yes, Your Honor.
All right. I'm going to take some testimony from you, so I'm going to ask you to raise your right hand and swear to tell the truth. Do that for me, please?
Can I act? No, never mind. We're good. I'm sorry.
If you have a question, I want to hear it.
So the attempted resisting and obstructing is a misdemeanor, correct?
Yes.
Okay, that's my final question.
Okay. Raise your right hand then so we can take some testimony from you. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can put your hand down. Has anybody promised you anything other than this plea agreement in order to get you to plead today?
No.
Has anybody threatened you in any way in order to get you to plead today?
No.
Are you doing this of your own free choice and free will?
Yes.
Are you doing this telling me that you understand what it is that you're doing?
Yes.
Do you have any further questions for your attorney?
I do not.
All right. I'm going to then ask you some questions about the facts of the particular case, and I'm going to do that first as to the attempted resisting and obstructing, and I'm going to try to do it in a way that lets you know what the new charge of attempted resisting and obstructing would say. Okay. So
Okay.
it would say that on or about March the 5th of 2025 in Bagley Township of Otsego County, that you did attempt to either assault, batter, wound, resist, obstruct, oppose, or endanger a police officer of the Michigan State Police. And there are two choices for that because there were originally two charges, either Jacob Kennedy or Michael Daniels, and that you did acts in the attempt of that, but did not successfully complete that charge. Is that true?
I believe so, yes.
Okay. On March the 5th of this year, where did you have contact with the Michigan State Police?
At the Iron Pig in Gaylord, Michigan.
All right. And did you do something that was either assaultive to them or that obstructed their investigation somehow?
That is what I read in the police report, yes.
Well, I can't have you tell me what you read in the police report. I got to have you tell me what you did. What did you do that was an attempt to either resist, obstruct, oppose, or assault or batter one of those two police officers?
I attempted to kick a police officer.
Okay. Did you know that he was a police officer at the time that you attempted to kick him?
Yes.
Can I assume rightly that you were angry at him by your attempt to kick at him?
Yes.
All right. And was he in full uniform so there was no doubt in your mind that he was a police officer at the time?
Yes.
All right. Do either attorney have any questions as to a factual basis?
No, Your Honor.
And not as that charge, Your Honor.
All right. As to the second charge, the one of operating while intoxicated, on that same date, time, and place, did you operate a vehicle in an area designated for the parking of vehicles, that is the parking lot of the Iron Pig, while you were under the influence of alcoholic liquor? Is that true?
Yes. Yes.
All right. How much had you had to drink before you operated your vehicle in the parking lot?
I'm unsure of how many exactly I had to drink.
To the best of your recollection.
Oh, goodness. At least a few mixed drinks.
All right. And what vehicle were you driving in the parking lot?
My vehicle, my white Ford Edge.
All right. And did the amount of alcohol that you drank prior to your operation, did it cause you to be under the influence of alcohol at the time that you were using or operating the vehicle?
Yes.
Well, you gave me a question there, not an
Sorry.
answer.
Yes, I'm sorry. Yes. I'm
All
really
right.
nervous. I'm sorry.
I totally understand. That's why I'm not mad at you. So you just answer it the way that you want to, and I'll get through this with you. We're doing fine. So you do believe that you were under the influence of alcohol at the time that you operated your vehicle in the Iron Pig parking lot, right?
Yes.
All right. Any questions, counsel, as to the factual basis under count 3?
No, Your Honor.
I don't have any questions. I would indicate for the record, and I assume the prosecutor would stipulate there was a blood draw done, and the results were a .246.
That's a bit more than a couple of mixed drinks. That's a lot. That's 3 times the legal limit. She was yeah, she was a little bit baked, fried, toasted, slammed, drunk.
All right.
That's accurate.
Ms. Wanford, do you agree with your counsel that that was the blood test results of the amount of alcohol in your system?
Yes.
All right. Are either counsel aware of any other promises, threats, or inducements not stated on the record?
No, Your Honor.
No, Your Honor.
And do both of you believe that I've complied with the court rule in taking pleas?
Yes, Your Honor.
Yes, Your Honor.
All right, I will find that there's been a proper factual basis established as to the attempted resisting and obstructing by kicking a police officer that she knew was a police officer within the city limits of Gaylord at the Iron Pig restaurant, and also that she operated while intoxicated because she operated a vehicle within the area designated for a parking vehicle at the parking lot of the Iron Pig while she was under the influence, and that is also supported by the blood alcohol level being substantially more than the legal limit. And I will accept both pleas, finding that they were knowingly, intelligently, and voluntarily made. Give me just a second to catch up on my paperwork. All right, Mr. Truce, I assume that you want to proceed directly to sentencing, is that correct?
I would not have an objection to that. I don't suspect that there is a victim who would want to allocute. So if the court is prepared to do that, we would be prepared to proceed.
I was just going to ask Mr. Fortier that, do we need to wait for a victim or can we proceed today?
Your Honor, there was an individual whose vehicle was struck, and part of any sentence we would be asking for restitution. However, we haven't been able to touch base with her yet. So at this point, I mean, but for that reason, I wouldn't have any issues moving forward. But I think in light of that, I would ask for some time. Our last attempted contact with her was yesterday. So that was obviously pre any plea. So we would like.
Yeah, and that's fine. That's perfectly acceptable, and you have the absolute right to do that. So I will grant that. When's my next time available?
28th.
All right, we're going to reset or adjourn this out to the 28th.
Sorry, Richard Truce isn't available on the 28th.
No, you're not available, Mr. Truce.
We can do the 29th.
So the 29th will be 2 weeks. We'll be back here on the 29th. You'll get a notice in the mail. I get myself in trouble if I start giving dates and times more than that. So we'll simply adjourn for sentencing, restitution issue. And Ms. Wanford, we'll have you back here in 2 weeks to discuss what to do with your particular case. Mr. Truce, anything else for today?
No, Your Honor, thank you.
Mr. Fortier, anything else?
No, Your Honor, thank you.
All right, that's all for today then. Thank you very much.
So I can leave now?
You can go right ahead. Thank you very much.
Okay, thank you.
You're welcome. All right. Next person we have is State of Michigan versus Dominic Kalinsky. We actually have 2 files on that. First is 25-43591-FY, and the next is State of Michigan versus Dominic Kalinsky 25-43612-FY, both set for a status review hearings.
Yes.
Do we have a resolution in these matters? Go ahead, sir.
James Dick on behalf of Mr. Kalinsky. Your Honor, we do not quite yet have a resolution. He has been accepted into the drug treatment court. I am just waiting on a response back from Ms. Brucker as to a global resolution.
All right, it looks like there has been an amendment to the charges. Let me make sure I've got that correct. Yeah, Mr. Fortier, could you tell me what the change has been or is?
I believe.
Looks like it went from 4th degree to 3rd degree. Is that correct?
I think so.
Count 1. Yeah, I do see that difference now.
Yeah.
All right. Let me do that. And then is there I've received a bond condition form that are the standard ones for sobriety court that need to be added before he can begin implementation of that. Mr. Dick, is it acceptable for you that I arraign him on the amended complaint, changing count 1 from in file 43612 from a pleading elude 4th degree to pleading elude 3rd degree, and then add the bond conditions? Would that be sufficient for your needs today?
Yes, he does need to get started with his programming. So,
all right. Mr. Kalinsky, I want you to listen carefully. It looks like the prosecutor has changed the count 1 from police officer fleeing and eluding in the 4th degree to police officer fleeing and eluding in the 3rd degree, which is a slightly higher degree of penalty and case. So I believe that the habitual offender and the count 2 are exactly the same, so nothing's changed other than count 1 being changed, and it reads as follows: that on March the 27th of 2025 in Elmira Township of Otsego County, that you did commit the offense of police officer fleeing and eluding 3rd degree, in that being the owner being the operator of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by Deputy Frank Rock, a police officer who was in uniform, and the officer's patrol vehicle was identified as an official police vehicle acting in the lawful performance of his duty, directing you to bring your motor vehicle to a stop, did willfully and fail to obey such direction by attempting to flee or elude the officer, and further appearing that on or about April 25th of 2023, you were previously convicted of fleeing and eluding, commonly known as fourth-degree fleeing and eluding in the 17th Circuit Court. Therefore, this violation constitutes a third-degree fleeing and eluding, and it has a penalty of 5 years and or a $5,000 fine. Secretary of State shall suspend your operator's chauffeur's license for a period of not to exceed 5 years. Do you understand the new charge, the name of the new charge, fleeing and eluding in the third degree?
I understand the name of it. I'm just wondering why it changed.
Well, that's up to the prosecutor. It's his discretion to charge what he believes is the appropriate charge, and he has the right to change that when he believes it's appropriate. If you believe that it is not legally merited, your attorney can file a motion to dismiss, but the prosecutor always has the discretion to change what the charges are.
Okay.
So that's the reason for it. Yeah. So you understand the name of it, and do you also understand the penalty is 5 years and or a $5,000 fine? That's the maximum penalty that could be issued.
Yes, Your Honor.
I have not heard of them amending the charges up. I mean, they amend them down all the time, but I've never had a judge say the prosecutor has amended the charges and, well, you're even more screwed now.
All right, thank you very much. I appreciate that. As to the bond conditions, I understand that you are asking to be considered for implementation of the sobriety court, and the fastest way to begin that process is by agreeing to have your bond conditions changed to submit to the requirements of the drug court. Is that what you want to do today?
Yes, Your Honor.
All right. I'm going to read to you what those requirements are, and then I'm going to ask for your permission to sign your name to it because you're not in court with me to be able to sign it on your own. So here are the conditions of bond that you would have to agree to. All previous terms and conditions of bond remain in full force and effect, and these conditions apply even while my application is under consideration. Next one is that you're not to purchase, possess, or consume any alcohol, marijuana, or non-prescribed controlled substances. You must submit to random PBTs and drug screens. You're not to enter into any business that sells alcohol for the use therein or that sells marijuana until further order of the court and or drug court probation staff. You're not to operate any motor vehicle without a valid driver's license, registration, and insurance. You're not to engage in any assaultive, threatening, harassing, or intimidating behavior toward any person, and you are not to engage in any behavior that would constitute a violation of Michigan criminal law. You will call the Redwood testing number daily between the hours instructed by the drug court probation staff for confirmation of a drug screen and or a urine sample. And further, you will not provide a false or diluted sample to the testing authority. You will report to the Otsego County District Court daily or as instructed by drug court probation staff and will follow all rules of the Otsego County Drug Court. You will comply with no less than 2 AA or NA meetings per week as instructed by the drug court probation staff. If you relocate for any reason, you must provide the court with any updated address and phone number within 7 days of any such change. You are not to dispose, sell, or transfer the vehicle involved in this incident prior to the disposition of this case because the vehicle may be subject to impoundment by court order at the time of sentencing, subject to forfeiture upon your conviction, and furthermore, any disposition of the subject vehicle during the pendency of this case may result in felony charges being filed against you. You are not to purchase or possess any firearm or any other dangerous weapon, and you are to ensure compliance with bond conditions. You are subject to search of your person, property, and electronic devices, including providing passwords or passcodes for the electronic devices without the need of a search warrant if there is a reasonable suspicion to believe that you are in violation of a term or condition of your bond. Do you understand all of the conditions that I've read to you?
Yes, Your Honor.
Your Honor, if I
You understand? Go ahead, Mr. Hamlin.
Real quick, I'll keep it brief. I need to know if he can report here to the court at or before 4 p.m. today. Otherwise, I'd respectfully ask the court to date the bond conditions for Monday of next week.
All right, Mr. Kalinsky, can you report by 4 o'clock today?
No, I'm at work and I have a client here. I'm about to do a tattoo.
And herein lies the issue then, Your Honor. There will be no drug screens, no supervision for 3 days, which he's ultimately losing credit for 3 days. So if the court orders him to be here for 4 o'clock, then we can do bond conditions on today's date. Otherwise, I got to do Monday of next week.
That's your call, Mr. Kalinsky. It's 3 days now or 3 days later.
3 days later, I guess. I got a client here.
All right. So I'm not going to date it for today. I'll date it for, which would be May the 19th. Do I have your permission, Mr. Kalinsky, to sign your name to this document?
Yes, Your Honor.
Sir, you need to be here at 8 a.m. Monday morning.
Okay.
All right. That's all for today then. Thank you very much.
Thank you.
Thank you, Judge.
The first McDonald's restaurant was opened in 1940 on this day by brothers Richard and Maurice McDonald in San Bernardino, California. Fast food at its best, isn't it? Have a great day.
Well, I'd have to argue with the judge with the facts. I don't consider Macca's to be fast food at its best. Maybe at its fastest some days, but definitely not best. We do, but she was kicked out. She's out. Hey, man. I didn't send them. Yeah, yes. She was under my desk and it was awful. And so I took her out and I told her to stay out of the room. I told her. And then I smelled it again and I actually blamed Tiny Kitten. I turned around and Tiny Kitten was the only animal I saw until I looked over and on the other side of the desk, I see Ava grinning at me and thump, 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 tapping her tail. She did it on purpose. I hope you guys had a good time tonight. I think we had more fun in the chat. Y'all are going to have to watch the Replay Crew minis for the cases. Hey, man. I don't do that. Oh, my girl. My girl. I love her. I love her, but she's not sleeping in the bed tonight. Nope. Yeah. Oh, that was funny. Yes, always just ignore me. Just ignore it. If it says that it's in 24 hours, it's not. Oh, I'm putting yours together too. Like I said, be expecting something in roughly 3 weeks. Thank you guys so much for coming out. I love you guys. I love every one of you. Be safe, be well, sleep sweet, and much love.